A woman gets trapped in a public toilet. A doctor sends a poisoned patient home. And somehow both stories help explain one of the most important ideas in negligence. Here's a short extract from one of our CILEX CPQ tuition videos.
So, without much further ado, like most things in law, this is best explained with an example. So let's have a look at Mrs. Sayers' unfortunate day. Now, Mrs. Sayers visited a public bathroom maintained by Harlow Urban District Council. Unfortunately for Mrs. Sayers, after locking the cubicle door, she discovered too late and with a sort of bone-chilling horror that the inside handle was missing. So Mrs. Sayers had effectively locked herself in the toilet. For 15 minutes, Mrs. Sayers called for help and she shook the door and she tried attracting attention in all the ways that she knew how, but unfortunately no one came. And faced with the prospect of indefinite confinement, staying in the loo for all of eternity, she resolved to climb out. So, how did she try and climb out? Well, she put one foot on the ceramic toilet seat and the other on the toilet roll holder, and she gripped a pipe and the top of the door for balance, and she began her ascent. However, almost at once, she gets up on there and she realises that the gap above the door is actually too narrow for her to get through. So she begins to climb back down, and on her way down, the toilet roll holder spins, the spindle turns, her foot slips off, and she falls heavily to the floor, and she is obviously injured. So it's really not a good day for Mrs. Sayers. So with these facts in mind, who needs to bear legal responsibility for Mrs. Sayers' injuries? Is it the council that left her locked in? Or has Mrs. Sayers broken the chain of causation by doing that risky manoeuvre where she climbed up onto the toilet roll holder? This is where causation can get really quite tricky. And the case of Sayers and Harlow Urban District Council is a really good example of these complexities. So we're going to leave you in suspense for a little bit longer in this video as a sort of incentive for you to keep watching, and we'll come back to Mrs. Sayers and you'll get your answer later on. In the meantime, we need to think in a bit more detail about causation, what it is and how it works. So, we are facing the final hurdle in proving a claim in negligence law. Let's say you've already established your duty of care exists, you've already proven that the duty has been breached, and now you need to prove whether the breach was the cause of the harm. If an injury or damage or whatever it is happened for other reasons, the defendant might not be liable at all. So that sounds fairly simple. And to be honest, causation is fairly simple. We just need to break it down in a little bit more detail by thinking about the different types of causation. So there's one type of causation known as factual causation, and that is basically evidence of a direct link between the defendant's negligent act and the damage suffered by the claimant. In simple terms, was it their fault? Then there's legal causation, so whether the harm was too remote from the defendant's negligent act for the defendant to be liable. In other words, was the harm too far away? Both of these things need to be proven for the claim to succeed. You need both factual and legal causation. So we're going to start with factual causation as the courts do. Factual causation is determined using this thing called the but-for test, which means but for the defendant's actions would the consequence have happened. It's a bit of a kind of old style of phrasing something, but it basically means if the defendant hadn't done what they did, would the thing have happened? So let's look at how this works. First of all, you ask, would harm have occurred without the defendant's conduct, even if the conduct is refusing to do something or failing to do something? And if the answer to that question is yes, then you have established factual causation. Hooray! But it's not always that easy. So, we need to look at this using some cases, as always. And we're going to start with Barnett and Chelsea and Kensington Hospital in 1969. Let's set the scene. You're in a busy emergency department and a patient comes in with vomiting and stomach pain. A nurse relays the symptoms to the duty medical officer, who, without examining him, advises that he goes home and talks to his general practitioner later that morning. So he's coming in sort of middle of the night. 5 hours after leaving the hospital, Mr. Barnett died from acute arsenic poisoning. So, on the facts, the doctor has clearly breached his duty of care by failing to see the patient. But expert evidence showed that actually, even with the world's best treatment, he would not have lived. There was no treatment that would have saved Mr. Barnett's life. So, applying the but-for test, i.e. would the consequence have happened but for the doctor's actions, the court held that this negligent omission, i.e. this failure in his duty of care, was not the factual cause of death. Mr. Barnett would have died regardless, and therefore the doctor could not be seen to be the cause of death. Therefore, the claim failed. So that's one really, really useful example for you to draw on.
That was just a small sample of the CILEX CPQ Foundation tuition our students get access to. As you've seen, we use real cases and clear explanations to help make tricky legal ideas like causation much easier to follow. Across F1 to F6, we have over 58 hours of video content to help support your studies. Visit the Astranti website to find out more about our foundation course, or sign up for our free F1 to F4 mock exams if you're already studying.